The Child Justice Amendment was one of the bills debated during the recent House of Assembly session. The original Child Justice Act, introduced in 2018, set up legal procedures for addressing cases involving children and young people accused of crimes. The proposed amendment aimed to grant judges the authority to impose sentences of more than 3 years on offenders. Prime Minister Honorable Philip J. Pierre gave a summary of the proposed changes.
The bill basically amends Section 54(2) of the Act by replacing the power of the court to impose a sentence of 3 years with a provision which grants the court a discretion to impose an appropriate sentence. The bill also amends Section 881(3), correcting the reference to the provisions of the Criminal Code, Cap 301, which has been replaced under the Act. Mr. Speaker, basically, it is allowing the court to use its discretion to impose a sentence on a child instead of what happens presently.
However, this proposal has sparked debate among lawmakers, with the parliamentary representative for Shrewsbury-Saltibus, Honorable Bradley Felix, raising concerns about its potential implications on judicial discretion and fairness.
Mr. Speaker, I'm of the opinion that why fix what is not broken? And we may try to bury our head in the sand, but there is a perception in our public space as to how justice is meted out in our courts. And I think providing this subjectivity to a judge, Mr. Speaker, can only continue to fuel such a perception. And we have seen in the past where judges or magistrates have that discretion, and for example, when it comes to a gun-related offense, where some offenders may get a slap on the wrist and others may get, the whole 9 yards thrown at them. And as a result of that, Mr. Speaker, I am of the firm belief that, we really should not interfere in what has been working.
In his remarks, Parliamentary Representative for Vieux-Fort South, Honorable Kenny Anthony, echoed Felix's concerns, cautioning about the considerable power and discretion granted to judges.
When I see an amendment, and I have no doubt that the Prime Minister is very well-intentioned, the Cabinet of Ministers is very well-intentioned, the government is very well-intentioned, but I think when these things arise, we all need to stick a pin and ask the fundamental question. Should we be denying the legitimately elected members of Parliament the right to offer prescriptions to the problems that we have? Should we be denying legislators the right to say what a sentence should be for an offense? Should we? And why is it that we are giving judges more and more the power to legislate and make decisions for us? A judge exists to judge on what the legal prescriptions are, not to make new law constantly on his or her own. That is why I would support the St. Lucia Civil Code any day, and I reject any and all attempts by English-trained lawyers to abandon the Civil Code in preference of the common law. Because the Civil Code is written law. It is what Parliament and the people of St. Lucia want to be their law. The law should not be in the breasts and in the minds of judges. And so, Mr. Speaker, I share the reservations of the honourable member for Swazelle, but in a different direction, because we are ceding, we are abdicating, we are extending powers of judges where that should not be the case.
The ongoing debate underscores the importance of balancing justice with the rights and welfare of young offenders. For Choice News Now, I am Darrell Lionel.